Come to order, please. Good afternoon, and welcome colleagues, invited guests, and members of the general public who are following today's proceedings of the Standing Senate Committee on Legal and Constitutional Affairs. We're continuing our pre-study on Bill C-36, an act to amend the Criminal Code in response to the Supreme Court of Canada decision in Attorney General of Canada v. Bedford, and to make consequential amendments to other acts. The committee has held 3 days of hearings thus far on this pre-study, hearing from 48 different witnesses. Our first panel today, appearing by video conference from Charlottetown, Prince Edward Island, a familiar face who's appeared before this committee on a number of occasions, Mr. Tom Stamatakis, who's the president of the Canadian Police Association. Mr. Stamatakis, thank you for appearing before the committee once again, and I'd like to give you this opportunity for an opening statement. Please proceed.
Thank you. Thank you, and good afternoon, honorable senators, and to you, Mr. Chair. I appreciate having the opportunity to appear before your committee today as part of your study of Bill C-36 on behalf of the Canadian Police Association. I believe I've had the opportunity to meet most of you before, but for those who may not be familiar, the CPA represents over 54,000 frontline civilian and sworn law enforcement personnel serving across Canada in over 160 police services. I'd like to begin my brief opening remarks by saying that the Canadian Police Association is supportive of Bill C-36, though we certainly understand that this legislation, like prostitution in general, is a controversial topic. As I mentioned during my appearance before your colleagues on the House of Commons Committee, our association certainly appreciates that Minister McKay and Minister Blaney, as well as the Departments of Justice and Public Safety Canada, actively consulted with frontline law enforcement during the drafting process for this legislation. As a frontline officer myself, I appreciate and understand that the issue before you here is a complex and controversial one. But I believe that there are some areas where all sides can come to an understanding, particularly with the need for us to focus on protecting the most vulnerable and exploited members of our communities, and that's where we believe C-36 makes some very positive steps. Provisions within this proposed legislation which clarify the definition of a weapon within the criminal code to include restraints, including handcuffs or rope, which are used in the commission of certain offenses, will certainly help provide additional and necessary tools to our officers. Further, the increased penalties attached to child prostitution, child trafficking, and related offenses will hopefully send a very clear signal that there will be absolutely zero tolerance given to anyone who preys on or exploits those who are in most need of our protection. I know that a comment I made during my previous appearance stirred up a good deal of commentary, particularly online from those who are following the study of this legislation. But I believe it important enough that I want to say it again. The fundamental point I'd like to stress is the absolute need for law enforcement and sex trade practitioners to end the adversarial nature of any interactions between these two groups. There is some misconception that pre-Bedford, law enforcement made it a priority to harass and arrest sex trade workers on a regular basis as part of a targeted attack on what many might call the world's oldest profession. I can say, both from my experience with my home police service, the Vancouver Police Department, and from my conversations with officers involved in these investigations across Canada, That's just not the case. When sweeps are conducted to target street prostitution, the instigation is usually complaints from the surrounding community, which need to be responded to by our police services. Officers involved in prostitution task forces receive specific training and have access to community support programs to help sex trade workers who might themselves be the victims of exploitive relationships or suffer from some form of drug dependency. Further, police services across the country have initiated John School programs to help divert those who are purchasing sex and to increase their awareness of the victims that may be created by their actions. Regardless of whether C-36 is passed, I would suggest that we need to continue to monitor and enhance these programs where possible to ensure that education is a key component for both the buyers and sellers of sex, and that resources will need to be committed to further those efforts. When it comes to prostitution, as with many other offenses, Canadian police personnel exercise a tremendous amount of discretion in the pursuit of their duties, and this will continue even if C-36 becomes law. Many of those involved in the sex trade come from the most vulnerable and marginalized members of our society, where violence and addiction are common themes law enforcement encounter. Any legislative response to prostitution in this country needs to take those factors into account, as the harm that is caused not only impacts the buyers and sellers of sexual services, but also the surrounding communities. To conclude, I want to reiterate that the Canadian Police Association endorses the approach taken with Bill C-36. This legislation will provide frontline law enforcement personnel the additional tools they need to help target the predators who seek to take advantage of the vulnerable. Our members appreciate the enhanced penalties for offenders that target children and those who try to draw minors into this industry through child trafficking. The recent Bedford decision has had a significant impact on policing in this country due to the uncertainty that has followed regarding the constitutionality of Canada's laws surrounding prostitution. And we appreciate that this government has taken steps to address that uncertainty and that law enforcement was a part of the consultations that took place in order to draft this legislation that you are considering. So I kept my opening remarks brief to allow as much time as possible for questions, and I look forward to participating in the continued discussion here this afternoon. And thank you again for inviting our association to participate.
Thank you, and we'll begin those questions with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and welcome to the witness once again to give testimony before this committee. He's been very helpful over the years as far as legislation is concerned and vetting the various sections of the bills. I do recall a great many reported cases in which you were involved, some drug cases, some shootings and so on, but I don't recall a prostitution case in which you were directly involved, Constable. Were there any?
Oh, I've had many dealings with prostitutes over the course of my career as a patrol officer, but I haven't been involved in any significant investigations involving prostitution or trafficking related prostitution, that kind of thing.
Yes, but you have very good contact, as you mentioned, with your fellow officers because you were, for many, many years, the head of the union in Vancouver, and we've read many of the arbitration hearing reports, and you've done a great job for your fellow officers over the years. Your message to us here today is that regardless of what's in the legislation, that police officers will continue to use discretion as far as prosecutions are concerned. Is that correct?
Yes, that's correct.
Could you explain that? Because the minister appeared before the committee, and the minister made quite a big deal of the fact that, as he put it, for the first time in Canadian history, prostitution will become illegal, will become unlawful. And do you see anything in the bill then that would change the attitude of the police toward prostitution that may result in many more convictions of the prostitutes themselves?
Well, I think I see almost the contrary to that. There are specific provisions in the bill that provide exemptions, for example, for the actual sex trade worker if she's engaged in certain activities that are related to her. And I think in many ways this legislation gives a strong message to law enforcement that it's not about targeting, the actual sex trade worker herself, who is often among the most marginalized or vulnerable people in our society, but it's more about targeting people who exploit sex trade workers, the people who take advantage of women who are in these vulnerable situations. But at the same time, it provides the police with the authority, though, to deal with sex trade workers when they are engaged in activities that could be harmful to other people in our community that we have an obligation to protect. Yes. So I think the bill provides the right balance, and it does deliver, in my view, a strong message to law enforcement that, here's where you should be targeting your activities, and here's where you should not.
Yes, so the exclusionary clauses that you referred to, which excludes the act of prostitution on behalf of the prostitute, the exclusions there in the bill are in answer to the Bedford decision, and you feel that provides the necessary changes in the law to address the Bedford case.
I think they do, and I think they do more than just change the law. Like I said, they deliver a message. And I think the other piece of it is that police officers use their discretion every day when it comes to enforcing, whether it's the Criminal Code of Canada, provincial statutes related to motor vehicle acts, other statutes where there are laws that are established around certain kinds of behavior, but we don't give every person we pull over a ticket. We don't arrest every person that where we respond to a call and there's an allegation that they've committed a criminal offense. We use that discretion every day, and I see police officers continuing to do that in this particular area, probably more now than they ever have.
Thank you, Mr. Chairman.
Senator Batters.
Thank you very much for appearing today, Mr. Stamatakis. You provide a very important perspective to this issue as you and your members across Canada deal with this issue of exploited women and children and others who are exploited through the prostitution industry every single day. So thank you very much for your work on behalf of Canadians in doing that. And I really appreciate what you just said, because we heard from many witnesses over the course of the pre-study hearings that primarily took place last week, that they were concerned about the possibility of prostitutes being charged. So I very much appreciate you confirming the significant discretion that police have and exercise every single day, and that will continue under Bill C-36 once it's passed. So thank you for that. I also wanted to refer to, you testified before the House of Commons Justice and Human Rights Committee back in July, and at that point you were quoted as saying that communication gives us an opportunity to intervene. The provisions around someone engaging in sex trade activities in front of a school, in a park, where it's causing other issues. The provisions around preventing youth from being drawn into the sex trade. Those are the kind of tools that Bill C-36 provides that I think police can use to protect vulnerable people in our community, quote. So given that, you have said that the old communication provision contained in the criminal code allowed police an opportunity to intervene with the prostitute, determine if that person is being exploited, and then direct them towards resources. And I'm wondering if you feel that the provisions of Bill C-36 will afford you that same opportunity.
Yes, I do. And when we were canvassed for input as the legislation was being drafted, that was one of the key pieces from our organization, was we needed to have the legislative authority to insert ourselves into situations lawfully so that we could determine what was happening in a particular situation. And I think with the provisions contained within this proposed legislation, we're able to do that. And then this is where I think police officers will use their discretion then to make decisions around how to proceed after that. But without the lawful authority to intervene, particularly when you're talking about the most marginalized people who become involved in the sex trade, whether it's women or men, and I know it's predominantly women, without the lawful authority to intervene, how are the police ever able to determine whether someone's being exploited or if they're engaged in an activity because they voluntarily, on their own, choose to do so without being coerced in any way?
Thank you. Do you feel this bill strikes an appropriate balance between the safety of prostitutes and the safety of communities? Because as a law enforcement officer, I'm wondering what tools you think Bill C-36 gives you to achieve both of those goals, which are both very important goals.
I think it does. I think it does achieve that balance, and I'll just refer back to my previous comments around some of the exemptions where, you know, someone engaged in prostitution in a public place, but not near a school, not near a place where, you know, children are present or that typically go to, and provided that activity is not causing any harm to a particular area in a community, where it's not affecting the quality of life of other citizens, or it's not exposing children not in a playground or in a school to risk or inappropriate behavior. I would say that, generally speaking, the police are not going to get involved in those situations. I mean, quite frankly, we don't have the capacity to be so focused on prostitution that we would be looking at those kinds of situations. But on the other hand, the legislation does provide us with the ability to intervene and take some action if, in fact, the activity is causing a harm to other people that we have an obligation to also protect.
Thank you very much.
Thank you. Senator Joel.
The Chair, welcome, Mr. Stamatakis. I would like to come back to your answer because to a point it puzzles me, because I see a nuance in the proposed legislation to what you just mentioned, that, in other words, if the prostitution happening is not an annoyance to a community and there is a complaint to the police, you would be more, I would not say tolerant, but, you know, you would not be bothered by it. That's not exactly what the bill says. Section 213, if I read it to you, and it's on page 7 of the bill, and I read it. I don't know if you have the bill with you, sir.
I'd have to look it up on my device, or if you want to read it,
I'll try to read it slowly. Everyone is guilty of an offense punishable on summary conviction who, in a public place or in any place open to public view, for the purpose of offering, providing, or obtaining sexual services for consideration. So, in other words, it's an open-ended offense, whatever is the complaint. If it happens, if the offering or effort to obtain a sexual service is done in a public place, it is per se, an offense. So it seems to me that, I don't know, I ask you your interpretation of the bill, doesn't need for you to I would say have a complaint that somebody, you know, doesn't like to see a prostitute in front of his door or in front of his entrance. It is essentially an offense if a person is offering sexual services, or another person tries to obtain a sexual service from a person. In other words, the purchaser or the person offering. Your interpretation seems to give some nuance to that. Could you restate your answer in relation to that?
Sure. Clearly it's an offense. I'm not suggesting that it's not, but I think what I was trying to explain is you know, the police have a responsibility to respond to issues or concerns that are identified by the community, and we balance that obligation to respond against our capacity to do so, the resources that we have, et cetera, et cetera, et cetera. And going back to my earlier comments around, this is where the office of a police constable in our society, in our democracy here in Canada, provides for that level of discretion. So what I would say from a frontline policing perspective, representing the members that I represent, which are the people on the street who are juggling a lot of competing demands, I would say that in that circumstance, if there's not a harm being caused to some other person in the community, if there's not some aggravating factor, typically the response from a police officer would not be to charge that person with a criminal offense. We don't have the capacity in the police community to set aside our discretion and charge every citizen every time they ever might be about to commit an offense or are committing an offense. We use our discretion. We take factors into consideration like where is this happening, who's affected by it, what kind of a person are we dealing with? Is this a marginalized person that actually needs assistance that they can get better from other resources as opposed to being arrested and incarcerated? Those are the kinds of considerations that come into play anytime a police officer is enforcing any provision in the criminal code, and I don't see police officers doing anything different with this legislation.
Were you consulted on the redefinition of the section of the criminal code that deals with the definition of common body house? Because as you probably know, the code, the proposal C-36 contains a redefinition of a common body house that remove prostitution from the definition. You might be aware about it. It's section 11, or I should say 12. Sorry, section 12 of the bill, and I read the section slowly for you, sir. Common body house means for the practice of acts of indecency, a place that is kept or occupied or resorted to by one or more persons. Before, the definition means common body house means for the practice of prostitution or of acts of indecency. Were you the one who suggested that there be a new definition for a common body house?
No, we didn't make specific recommendations or suggestions around the definition. I have to say, though, in reading the proposed legislation, I wasn't troubled by the definition at all. From a frontline policing perspective.
If I may, another question.
Quickly.
The bill, as you know, the proposal of the bill is to criminalize the purchaser of sexual services. What kind of approach will you have to that new offense, or the fact that the offense would be targeting purchaser, or I should say customer? What will be the different approach that you will have in relation to the way that you approach in the past, as you said yourself, prostitute? You seem to be more concerned about the prostitute themselves than by the customers or the purchaser. Could you enlighten us on that on the basis of your experience?
Well, let me just say from a personal perspective, and then falling back on my experience as a patrol officer in the city of Vancouver, I don't have a lot of empathy for purchasers of sex and the activities that they engage in. I mean, these are people, in my view, that do exploit vulnerable women and often take a lot of advantage over those women who have no ability to defend themselves or protect themselves against some often pretty abhorrent behavior. So I don't have a lot of empathy for purchasers of sex, but I think the approach we would take is the one that I described in my opening comments. I think there's a need to educate people around the harms that are caused by these behaviors. I think, again, we would use our discretion to find what the best avenues are to try and create opportunities for that education and prevent continued similar behavior.
Senator Plutt.
Well, again, welcome here, Mr. Stamatakis. It's good to see you again, and I also want to thank you for the many appearances that you have made in front of this committee. I want to thank you for all the work that you do for your association and for what all of you and your colleagues do for everybody in our country. I want to specifically ask you about the clause 213.1.1. Senator Joel touched on it. Senator Baker has in previous meetings directly asked the question about how do you feel about it, and surprisingly he didn't ask that this time. I'm wondering whether he knew the answer. But I would like to ask you, Mr. Stamatakis, how do you feel about 1.1 of Clause 213, where it is specifically an offense for a prostitute to be selling her services in a public place next to a school ground, playground, or daycare center? Do you have specific comments on whether or not you support that, and do you think the ability of the police to arrest the prostitutes in these limited circumstances is a valuable tool?
Absolutely. I absolutely support those provisions, and I think they're, quite frankly, in my opinion, they're long overdue, and I can give you specific examples of where the prostitutes engaged in their trade at schools, at daycare facilities, or other places where children congregate have caused harms. And those harms aren't always caused by the prostitute herself. Often those harms are caused by the people who are either purchasing the services of the prostitute, the people who are exploiting the prostitute and perhaps forcing her to engage in those kinds of activities. And the kinds of harms that I'm talking about are, I mean, I can give you examples in Vancouver where we have agencies where parents have to get together before the school day starts so they can sweep the playground for discarded syringes that are being used by prostitutes and others who are intravenous drug users and are using those locations to engage in that kind of activity. I've even personally experienced that as a resident of Vancouver, where I unfortunately had the experience of having the public space around my home used as a place for sex by prostitutes, while my kids were quite young and potentially could have been harmed by that behavior, whether it's interrupting a transaction or something like that. So I think that there are very serious harms that could potentially occur in those circumstances, and I think there's an obligation, quite frankly, on the government and on the police to be proactive and protect those, as I said in my opening comments, those very vulnerable people in our society, children, that need protection.
Thank you very much. Do you believe that either decriminalizing or legalizing prostitution would reduce any of the major harms associated with the industry? For example, we've heard so much about exploitation, violence, abuse, trafficking. If the sex trade was decriminalized or if it became legal, would those issues be lessened?
No, in my view, they would not. And I think, unfortunately, even if you were to decriminalize or legalize it, the very people that I think, a lot of well-intended witnesses are trying to protect would be the most, would become even more vulnerable, because those are the people that can't afford to or don't have the wherewithal to make sure they have the appropriate insurance coverages or access to workers' compensation benefits, and probably are the kind of people that wouldn't be welcomed into legal brothels or whatever you want to call them. Not to mention, and the most significant reason why I don't think legalizing it or decriminalizing it would really reduce the harms is because there's too many, quite frankly, men out there that are interested in engaging in abhorrent behavior, that want to, they get a charge out of doing risky things, and that will take advantage of women to exploit them, so whether it's for profit or some other reason. So I don't believe that legalizing it would make any difference, and we can just look at the issues that we have with alcohol and tobacco in this country, which are both legal products, yet consume a tremendous amount of resources, not just from the police sector, but from other sectors, whether they're funded by the taxpayer or by other means.
One more quick one? No, second round then, please.
Senator From.
Mr. Stamatakis, thank you for being here. We heard in our testimony numbers that somewhere between 10 and 20% of the sex industry is street prostitution. And my question to you is, for the other 80%, if that is indeed the correct number, I don't know if you have an opinion on that, but if that is the number, how difficult is it going to be for police to enforce Bill C-36 on the non-street prostitution? And I'm asking this in terms of either, collecting evidence or the resources, or you've talked about police discretion. How difficult is that going to be for you?
Yeah, and just to be clear, I'm not qualified to talk about what the numbers are, or the percentages are, but I think these cases, particularly the non-street sex trade cases, are extremely difficult at the best of times, and I think that's why I said earlier, having the legislative authority to intervene will be of some assistance, because you can get exploited women, for example, away from their pimp or the madam that's running the brothel in a residential house in a neighborhood in a city, some city across this country. If you can get the prostitute away from whoever's coercing them, you can get information which becomes then the evidence that you rely on to investigate and hopefully successfully prosecute these cases. But these are challenging cases because we're dealing with people who are being exploited, coerced. They're afraid. They're because of the violence that's involved when they are being exploited. And obviously, the purchaser of the services, these are not the people that come to us and say, by the way, there's a body house or some other off the street activity occurring in a neighborhood or an apartment building. So they're always challenging cases. We rely on, the neighbors, like at any other investigation, other sources to initiate investigations, and then it's up to our members to use whatever investigative techniques they can to gather the appropriate evidence, but they're very challenging.
But the police are going to have to want to investigate. And we did hear from one witness that effectively in many jurisdictions the police haven't bothered sort of prosecuting or trying to arrest anybody to do with the existing laws with prostitution. They're just, as you say, they've been exercising their discretion, and their discretion has been to not really pay very much attention to it. So is anything going to change with this bill?
Well, I think part of the reason for the lack of enforcement has a lot to do with the uncertainty that I referred to earlier. I think that's contributed as much to the lack of enforcement as anything, because, quite frankly, police have been quite often criticized when they have tried to respond to concerns in their community by taking enforcement action. So, if we can end up with clear legislation that is not contentious, and I'm not sure how possible it is with this specific legislation, that would go a long way to assisting police and being a bit more consistent and clear with enforcement decisions.
Thank you. Thank you, Chair.
Thank you. Senator McIntyre.
Thank you, Chair. Thank you, Mr. Stamatakis, for your fine presentation. My question has to do with the definition of the term weapon, upon which you've touched briefly a while ago. As you know, the definition of the term weapon in Section 2 of the Code is extremely broad. Specific code offenses relating to weapons are, for example, carrying a weapon for a purpose dangerous to the public peace or for the purpose of committing an offense, assault with a weapon, sexual assault with a weapon. What's interesting with C-36, as you've noted in your presentation, is that it supplements the definition of the term weapon by adding the following, and I quote, anything used, designed to be used, or intended for use in binding or tying up a person against their will, end of quote. How important is it for C-36 to supplement the definition of the term weapon? How important is it for police officers? Yes.
Again, from my perspective as a frontline police officer, I think it's extremely important, and this was a specific area where we did provide input through the opportunities that we had to consult. and I guess I'll come back to my experience again as a patrol officer on the street. I had many occasions where I would pull over a vehicle driven by someone, often with no criminal record, but with duct tape, ropes, those kinds of equipment in their vehicle. And I think with this enhancement in the definition, it'll give police officers an important tool to be able to at least continue an investigation or make some more inquiries, and perhaps be able to prevent more instances where sex trade workers are seriously assaulted by people who have these items in their possession for the purpose of harming sex trade workers.
Okay, thank you, sir.
Okay, thank you. Senator Desjardins.
Merci, Monsieur le Président.
Thank you, Mr. Chairman, and good afternoon, Tom. It's always a pleasure to see you. I'd like to come back to your opening remarks. You stated that the discretionary authority that police officers have is very broad. I understand that, being a former police officer myself. So I'd like to give you two examples. We heard sex trade workers who came as witnesses, and they often are, for example, carrying out their profession in massage parlors. Obviously, these massages are offered, and sometimes part of their training involves what they should say when police officers visit these massage parlors to inspect them. Now, sometimes when there's a raid, you need a warrant, and that warrant comes on the heels of an investigation. Now, from what I understand, is that you can exercise your discretionary authority in these massage parlors. So police officers have a decision to make. Now, if you're in front of a school, for example, or in a park, then there are transactions that are being undertaken near vulnerable persons. Perhaps you're dealing more in that case with, for example, street gangs. For example, there was Operation Scorpion in Quebec City where there was recruitment of young people. So what I'm trying to say is this the sort of situation where you would exercise your discretionary authority? Is it easier in some places than in others? And you'll have to exercise that discretion, for example, in public places, but it might be more complicated in places like massage parlors. So that discretion would be different in both places.
Yeah, I think that's a fair way to describe it. I mean, certainly if we were intending to take some enforcement action in a premise or a dwelling house, the threshold becomes much greater in terms of gathering the evidence that gives you the grounds to enter the premise and do whatever it is, take whatever enforcement action is appropriate. But it does apply in both. Like, I could see myself, if I think back to working again on the street, there would be times when, if I was received a complaint that there was a sex trader near a playground, I might, depending on the circumstances, I might choose not to arrest that person, and I might try and divert them to some other service, or it's very situational. And there are many other occasions where I haven't had personal experience, but where I talk with my colleagues that work in vice units, particularly in Vancouver, where there's some serious exploitation that takes place in these massage parlors, where women are forced to work in them, where they're being assaulted by whether it's the customer or the operator of the facility, where it becomes a very high priority to get into that place, take some enforcement action, and stop the operation of that massage parlor. So again, it's all about what the situation is, and then police applying their training, their knowledge, experience to respond appropriately, all with the view to protect whether it's the sex trade worker who's being exploited, or whether it's the community member that happens to live in a particular area who's being exposed to harmful activities, or that person's child that potentially might be lured or otherwise coerced into considering a profession that, quite frankly, none of us should want any of our children involved in that profession. period.
Merci beaucoup, Tom.
Thank you very much, Tom.
Thank you, and thank you for appearing. Much of what I had to ask has been answered, but I did want to touch on just a couple of issues. The bill seeks to deal with safety of our communities and our citizens by reducing the demand for prostitution, and the approach here, as you pointed out and as the bill points out, is to go after the Johns, the pimps, and those that privateer off of this. And police forces deal all the time with changes in law. And you've mentioned earlier that there were something like 54,000 personnel in Canada, 160 police services. This bill has a real shift in policy in that it will see prostitutes as victims and those that are individuals that are being exploited. Do you believe, you've said that you believe it'll be accepted. Will it be adaptable, and how will you educate the shift here, the multitude of police officers that are in this country? And secondly, you mentioned this as well, but I wanted to just raise it because it was raised here, and I've read about it, that there may exist inherently or subliminally a dim light or a negative feelings between the police and the prostitution trade. Do you, and that's natural because, I mean, it's a dangerous industry. There's normally drugs involved, sometimes organized crime, that type of thing. So do you actually believe that they are treated and will be treated the way that this law is bringing about that they should be treated?
Well, let me just answer your first question first. I do think that this legislation is very practical, and I don't think it's going to be a huge challenge for police agencies to communicate out the changes in the law when the legislation, or if the legislation's passed. But I don't want to understate the importance of education, both for the police and for the purchasers of sex and society at large in terms of what we're dealing with. And if we really want to deal with this issue of prostitution and the harms that it causes, whether it's to the individual sex trade worker or to the community at large, we really do have to get at those underlying issues. Why do women find themselves being lured into this kind of activity? Issues around illiteracy, domestic violence. So it's very important never to lose sight of those bigger issues. And I do think that as part of the introduction of this legislation, the government has said, look, we're going to look at providing some funding and really paying attention to those programs. So that's a very, very critical piece. But that has to include the police too. And in terms of your second question, look, we've made mistakes in the police community for sure, and there are some pretty horrific examples of where mistakes have been made and where we've learned lessons from those mistakes. And I do have to say that I think attitudes in policing have changed, and we are shifting our thinking away from where it might have been 20 or 30 years ago, and really starting to understand, what kind of situation these women are actually in, and that they need help and assistance, and it's not about, always arresting and enforcing and incarcerating, and that just doesn't apply to the sex trade worker. I think it applies generally in our society and in policing in particular around really starting to understand the harms and balancing the need for appropriate enforcement and protecting society at large against trying to help people who are in vulnerable situations, whoever they are, and who are being exploited by someone or by a group of people or whatever the situation is.
Thank you.
Quick question. I think Senator Baker has raised questions about John schools on a couple of occasions during our hearings, and I was curious, are John schools an alternative measure to divert the accused from court, or are they part of the court process leading to a conditional discharge? How do they work?
And again, I'm not an expert in this area, but my understanding is it's both. You're either diverting or it's part of the court process where it leads to a discharge if you participate in the. It just depends on the circumstances and how it's used. And the whole idea is, as you I'm sure well know, it's just to try and educate purchasers around the harms that their activity is causing. I have to tell you though, I mean, I'm a big supporter of these measures to divert and focusing on education, but I think there has to be a continued and sustained effort, because I know when I talk to my colleagues who are engaged in this kind of work all the time in vice units, they have a lot of people that go through John School and then they come across them again and they have to start all over. So I think there has to be a combination of ability to divert and some enforcement options.
I guess my point is you don't see this legislation deterring the ability to utilize that as a way to gain greater understanding of the people who've been charged under the new offense in this act.
No, I don't think so, and I think it's important to continue to try and use these tools that have had some success in that way.
Okay, we'll start a second round with Senator Baker.
One question, Officer. I found your answer to the question from Senator McIntyre very interesting, and the reason why he asked the question, he's been dealing with words in the criminal code now for some 40 or 50, 30 years, sorry about that. And it takes on a new meaning, the definition of, the enlarged definition of weapon, putting it in the criminal code. And the way you explained it was that it would add to the indicia that an officer must arriving at what is commonly called articulable cause or reasonable suspicion for a detention at roadside was the example you used. And that's interesting because what you're saying is entrenching it in the criminal code means that it will be one more tool that the officer will have when making a determination of whether or not to detain somebody on the basis of suspicion before you proceed further. Is that correct?
Well, not entirely. I mean, I think by expanding the definition, it becomes a chargeable offense in the right circumstances. So it's not just a tool. It is a tool in the context that you describe it, but it's an opportunity for the police to actually charge with an offense because of the expanded definition in the right circumstances. So.
Yes, but that's what I understood you to say, that if an officer sees in the back of a car certain ropes or, as you put, tape, that's another indicia that could assist the officer in making a detention. I think you said that in your answer to Senator McIntyre.
I did say that, and I think the context that I was trying to give you was based on a personal experience where I have pulled over people with those items in certain circumstances where it causes me great concern, but I didn't really have an ability in the situation to take any kind of enforcement action just on the basis that those items were in the vehicle.
That's very interesting.
Okay, Senator Batters.
Thank you very much. I thought you made a really important point in one of your earlier answers, or perhaps it was your opening statement, when you said that C-36 does more than changes the law, it sends a message. And I think that is very important, especially glad to hear that from such a high-ranking person in the law enforcement community, that the police clearly understand the message that we are trying to send by this particular bill. I'm wondering if you could tell us a bit about some of the programs that you're aware of across the country that have been successful in different places at building relationships between law enforcement officers and prostitutes.
Ask you to be
I could
concise
probably talk a bit
because
about...
we're running overtime now, so I'd like to get the other senators on. So please respond to Senator Batters, but in as concise a way as you can, please.
Speaking specifically in Vancouver, where my home service is, we have all kinds of outreach programs now with groups that represent prostitutes, which I think have made a tremendous difference in the relationship, and I think that those are the kinds of activities that police need to engage in right across the country in all communities.
Thank you. Senator Joyal.
Yeah. Mr. Stamatakis, I have the Vancouver Police Department Sex Work Enforcement Guidelines in front of me. Can I make some quotes to you that you be probably familiar with them? And I quote page 5. Quote, when responding to sex work-related calls or situation, the Vancouver Police Department priority is to ensure the safety and security of sex workers. Police calls regarding violence against sex workers are a priority for assessment and response. And then page 3, the Vancouver Police Department does not seek to increase the inherent dangers faced by sex workers, especially survival sex workers. Therefore, when there are nuisance-related complaints against survival sex workers, alternative measures and assistance must be considered with enforcement a last resort. And finally, on page 4, often the sex industry involves consenting adults who may never come to the attention of the community or the police. Sex work involving consenting adults is not an enforcement priority for Vancouver Police Department. I have generally agreement with the objective of your directive, the way that they are framed or labeled, I should say. The problem I have with those objectives, where the Vancouver Police has been targeting the purchaser, as you stated clearly, is that I have in front of me an article of the British Medical Journal of 2014 by a group of experts that study the Vancouver Police Department experience in relation to targeting the customer, and here are their conclusions quickly.
Senator Joyal, we're running tight on time.
Enforcement policies targeting clients do not decrease the frequency of sex work for marginalized street-involved women. Instead, enforcement aimed at clients forces sex workers to more isolated space to avoid police detection and result in longer hours spent on the street. These enforcement practices also result in sex workers agreeing to see clients or provide services that they would otherwise refuse, thus placing them at direct risk of violence and poor health outcomes. The problem I have with some of the objective of the bill is that they run counter to the decision of the Supreme Court in Bedford that seeks to ensure the security of the sex worker.
Please pose the question, Senator.
What's your comment in relation to the conclusion of the report? Thank you.
Okay, let me just say a couple of things. One is, I'm not a high-ranking police officer. I'm actually a constable. That's not my report, and I don't speak on behalf of the Vancouver Police Department. I'm here to speak on behalf of the Canadian Police Association and the members, the frontline members that I represent. And what I would say is, if anyone thinks that the police are solely responsible for this kind of sex trade activity among our most vulnerable and marginalized, I would strongly disagree with that. And in fact, I would argue, particularly in Vancouver, based on my knowledge of my colleagues, there are police officers every day in Vancouver that go out of their way to refer these most vulnerable women to programs, to put them in touch with organizations that are specifically established to support marginalized sex trade workers. And I just don't agree that somehow the police are to blame for these harmful situations of these poor women, exploited and marginalized women find themselves in, I think that there are other drivers of that kind of activity. And the fact is that I think police officers, have a lot of empathy for people in that situation.
Okay, final question, Senator Platt.
Very quickly, Tom, we had witnesses that said that one witness that this had been her lifelong dream to become a prostitute, and others that suggested that this was only consenting adults, or mostly consenting adults, I should clarify, not only. In your opinion, what age do most girls start in prostitution? Do they wake up on their 18th birthday and say, I would like to become a prostitute, or are they already coerced and started well before that?
In my experience, and in my opinion, which is based on my experience as a patrol constable in Vancouver, we are coming across women engaged in prostitution long before they're 18. These are basically children that are being lured, whether it's because they're involved in a conflict at home and they ran away, or whether they were in an abusive environment at home and they ran away and they ran into the wrong person who lured them with promises of money or nice clothes or drugs. By the time, most, in my experience, particularly in the downtown east side, women who get involved in the sex trade are generally pretty experienced and in pretty rough shape by the time they hit 18, let alone starting to engage in this activity when they're 18 years old.
Yes, thank you, Mr. Stamatakis, for once again contributing to the deliberations of this committee. Very much appreciated. And members, we will suspend briefly. We have another witness who is appearing by video conference, and we'll have to have that arranged before we begin, but it should be shortly. Please. For our next panel, please welcome Alan Young, Associate Professor of Law at Osgoode Hall Law School. Professor Young is joining us today to speak about his role as counsel for the respondent appellant on cross appeal in Canada v. Bedford in 2007, and also appearing via video conference from Vancouver is Georgia Lee Lang. As a lawyer, Ms. Lang is appearing to speak about her role as counsel for one of the interveners in the same case, the Evangelical Fellowship of Canada. And we'll begin with the opening remarks. Ms. Lang, we'll begin with you. Please proceed.
Thank you. My name is Georgia Lee Lang, and I'm a Vancouver lawyer, as you've just heard. I support Bill C-36, and I congratulate the Canadian government for recognizing prostitution for what it is, the degradation and commodification of women and girls in order to please men. I'd like to debunk several of the myths that have been advanced by those who oppose Bill C-36. The first one is that prostitutes choose to work in the sex industry and they like it. I say that because some women have the ability and the emotional maturity to voluntarily choose this work, it does not mean that one ignores the massive library of research showing that prostitution is a survival strategy. It's a last option. And the very edifice of prostitution is built on the lie that women like it. A 1998 United Nations International Labor Organization report found that prostitution is one of the most alienated forms of labor in the world. Secondly, the opposition says that Bill C-36 will drive and push prostitution further underground. The empirical evidence from Sweden is that street prostitution was cut in half by the Nordic model, as working girls were free to sell their services without legal consequences in indoor locations. And this research comes from the Swedish government itself in a 2010 report entitled The Ban Against Purchase of Sexual Services, an evaluation from 1999 to 2008. With the decriminalization of common body houses in Canada, women and girls will be free to set up their own indoor situations or go online and advertise their services. They also say that Bill C-36 will make prostitutes less safe. It can't be sugar-coated. Prostitution is a dangerous way to make a living, and making it legal for women to sell sex will not change this. However, research shows that safety issues are present whether prostitution is legalized or decriminalized. If one works as a prostitute, no matter what the legal structure, there are very high odds of physical and sexual violence, as well as long-lasting trauma. And for this proposition, I cite a report done by Dr. Farley and 7 other researchers, a recent report, including a researcher from Vancouver Coastal Health, Ms. Jacqueline Lynn. The report is Prostitution and Trafficking in 9 Countries, an update on violence and post-traumatic stress disorder. They also say that Bill C-36 is a conservative moral crusade. Well, let me tell you that governments throughout Europe are adopting laws that embrace the Nordic model, including socialist governments in Sweden and progressive governments in Iceland, where the sex industry has been virtually shut down. The 12-year legalization experiment in Holland and in Australia has been a debacle. Prostitution has increased. Trafficking of foreign sex workers has increased. Pimps are now legitimate businessmen. Women and girls work underground rather than registering and paying tax. If one considers that equality for women is a moral issue, then yes, I agree, it's a moral issue. And finally, they say that Bill C-36 will not withstand charter scrutiny. This proposed law is a radical departure from its predecessor. Under the criminal code, prostitution is legal. Under Bill C-36, it is illegal for men to purchase sex. The law is no longer directed at activities related to prostitution, such as soliciting for sex on a street corner or operating a common bawdy house. This law calls a spade a spade. Prostitution hurts and exploits women and children. Bill C-36 treats women who sell sex as the victims they are. They will not face criminal sanctions unless they ply their trade in the immediate vicinity of school grounds, playgrounds, or daycare centers. All of these are easily avoidable. The nuisance premise that our current law is founded on is excised. The Act spells out the purpose and goals of the legislation, and the effect and the object is entirely different than what it was under the criminal code. The new goal is to combat exploitation of women, to address the risks of violence, to protect human dignity, and to promote human equality for all Canadians. The current legislation was struck down because the connection between the effect of the law and the object of the law, i.e. public nuisance, was illusory. It was taking a sledgehammer to maintain public order in respect of a legal activity. It was grossly disproportionate. Bill C-36 clearly states its goals: the illegality of the purchase of sex and the abolition of prostitution. Thank you for inviting me to speak today.
Thank you. Professor Young.
Yeah, thank you very much. I'd like to speak to you briefly on my perspective on the merits of this law, and I'd like to leave the constitutional analysis to the questions. I have a feeling that's what you want to hear from me, but I have a lot to say, and please stop me when I overstay my welcome. Just tell me when I've hit my point. I thank you for the invitation and opportunity to appear before this committee, but to be frank, I did not really want to attend because I'm deeply sad and disappointed by the aftermath of the Bedford decision. I'm disappointed because in 2014 the Government of Canada were given an opportunity to make history, and instead the government chose to repeat the mistakes of history. And I'm saddened because in repeating the mistakes of history, this government has created a regime which will hurt communities and is contrary to the public interest, as this law will push workers back into dangerous street forums. Now look, reasonable people will disagree over whether sex work is inherently degrading and destructive of the social order. That's a debate that happens in academic settings. But those who support the criminalization of purchasing sex, in my view, are just a passionate and vocal minority who do not represent the views of the majority of Canadians. The government has chosen to endorse and support an interesting ideological perspective which does not represent public opinion. In fact, since 1970, public opinion, in my experience, shows the majority of Canadians tolerate sex work as long as it's not being pursued in public forums. Most people believe criminalization is not an appropriate response unless people are doing their business on the streets or in the backyards of the nation. So in pursuing an ideology not supported by most Canadians, this government has created a regime which I believe will lead to an exponential increase in street prostitution as happened in the 1980s. The bottom line, the law gives Canadians the exact opposite of what they would like to see accomplished by the legal regulation of commercial sex. Turning to the challenge which triggered this disaster, I have a couple things I want to say. I started this in 2002, but it took 4 years to file in court to allow for extensive research and study. And the research demonstrated the current laws put sex workers in harm's way, and this challenge was brought to create a safe haven or forum for workers to do their business. This case was fueled by research, not by some pro-prostitution lobby. I don't even know what a pro-prostitution lobby is. Nobody in my case, and we had a lot of people involved, was interested or involved in large-scale business operations or the so-called industrialization of sex work. The case was done on a pro bono basis with the involvement of some 30 or 40 volunteer law students because everyone believed we had an irrational law and we wanted to invalidate it to prevent another Picton disaster. We called it the Safe Haven Initiative, as the objective was to provide a legal foundation for workers to move into a safer forum. Now, in spite of the fact that all the attention is put on street prostitution, as was alluded to by this committee, the police themselves have said 80% of the sex trade over the last 20 years has moved indoors. The case was designed to give a legal blessing for this move because this move was a safety-enhancing choice. Now look at how the government has responded to this. It's a very confused response to a very clear judgment. The government says, oh yes, we've listened to the Supreme Court. The law now allows sex workers to set up an indoor business, hire employees, and advertise services. Yet in the very same breath, the government in the preamble asserts that all sex work is degrading and should be eradicated. It is a legal oxymoron to say someone is engaged in self-degradation, but you can also say these very same victims have the ability to advertise a business they've established in an indoor location. This sounds like the government knows there is autonomous choice being made by independent and informed individuals, a far cry from the notion of inherent degradation. To say something's inherently degrading or exploitive is not an empirical statement, people. It's a statement of belief and faith. Legislation should not be built on faith and belief. It's no different in as hollow as saying, are people inherently good or bad? It's just a matter of an opinion. I know this committee has heard very sad stories of those abused by the trade, but I'm sure you've also heard uplifting stories of workers who cannot be seen as victims except through the distortion of an ideological lens. There are many stories and many different experiences in the sex trade, and this law ignores that nuance. No doubt, there are survival street workers who are truly victims of poverty, broken homes, drug addiction, and abuse. And for this vulnerable group, we need to construct meaningful safety nets to help these victims escape the cycle of violence and exploitation. But there are also, both on the street and in indoor locations, sex workers who have made autonomous and informed choices to engage in this work. And if you look at the over history, over the big period of time, we'll find powerful sex workers who have been influence makers and respected members of the community. Yet the government in this bill is saying they're all being exploited by purchasing men. Therefore, it's necessary to prohibit the purchase of sex from any worker, regardless of the worker's level of autonomy and independence. This is nothing short of myopic and foolish. You know, they don't even call the purchase of sex exploitive in the legislation. They call it commodification. Exploitation is real, people. Commodification is a purely abstract concept. And I have to tell you, it's puzzling to me in the modern era that we say we're going to now set out to combat commodification in sex in the context of a highly sexualized society where everyone in this room, if you choose to, can leave this place, go home and watch hardcore pornography on your cable provider. I mean, commodification is there whether you like it or not. It's kind of a weird battle to fight in the modern era. So in trying to address the Supreme Court of Canada decision, while at the same time trying to introduce a new ideological perspective, we've ended up with a law which sends out contradictory messages. And what's the practical implication of this? This is what I say will happen. Common sense dictates that the purchaser will not come to a place of business and will prefer to do business on the street. People will always choose to be moving targets over being a sitting target at a business premise which may be raided at any time without warning. So sex workers will always go where the business is, and the business will now be on the streets. So after 20 years of moving people indoors, which was in the interest of the community, we're now moving people back out again. And in the process, sex workers will once again be compelled to do business in the most dangerous of forms, the streets, and communities will once again, as in the 1980s, be exposed to the nuisance and disruptions of having sex work conducted in the streets and the alleyways of Canadian citizens. So,
I'm interrupting you, encouraging you to
20 seconds. Thank you very much. So, we've endangered workers and members of the community and members of the public, all in the name of fighting commodification and eradicating sex work. For some, this may seem like a worthwhile battle, but for most Canadians, this will be seen as a failed policy which will please a small group of ideologues at the cost of safety, security, and autonomous choice. Please do not lend support to this half-baked, irrational, and constitutionally suspect act of Parliament. Thank you.
Thank you, sir. We'll begin the questions with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman. Is there anything else you wanted to say, Professor? Tell us what you really think.
I worked on this for about 12 years, and there's lots of things I want to say, but I do want to give everyone a caveat and a warning because I listened to the presentation by Ms. Lang. Please check all sources when people say there is an overwhelming body of evidence that supports something or other. You have to look at the evidence carefully. That's what happened in the court case. People have always been making these assertions of what is sex work, who's involved in sex work. We provided 88 volumes of evidence, and that's why every level of court could understand what is going on in terms of sex work. It is not a lot of the statements where people say it's inherently degrading, and Melissa Farley has done a study in 9 countries that proves that. You read the study, then come back to me and tell me whether it proves that.
On that note, I want to congratulate you your initiatives at Osgood Hall regarding the wrongfully convicted.
Thank you.
And all of the other initiatives. You've made law in Canada. You've challenged laws that should be challenged. And you've done it, as you were mentioning, pro bono. Look, you did it in civil, under the civil rules.
Correct.
Under the civil rules, I'm sure you would agree with me that you run the chance of ending up with a big fat bill if you lose. The simple way to do this is through the criminal court with somebody charged, and then you can challenge the constitutionality of a provision without then ending up with a big bill in your back pocket. I've seen some of these bills, over $100,000 costs by the Justice Department when somebody loses a case. Is there any simpler way of doing this? It took you 5, 6, 7 years before the court, and why did you choose the civil route instead of the criminal court?
The sex trade laws are considered to be fairly minor. So if I waited for a charge and then raised in criminal court that I'm going to challenge the constitutionality, they always withdraw the charge. Better to save the law and lose the case. So I had to take the initiative to make sure I couldn't be derailed by the Crown withdrawing the charge. It was the same thing in the pot world with the marijuana case.
Yes.
It was very hard to raise the challenge because every time...
In the federal court?
Well, in terms of medical marijuana,
yes.
But we lost in terms of the Supreme Court of Canada on marijuana possession. But law is expensive. Law is slow. Law is procedurally laden. Is there an easier way? Yes. Get the legislation right in the first place so you don't have to do the constitutional challenge. That's the only solution.
Can this bill be amended?
No. It is inherently contradictory. The government has to decide what they're responding to. Is it a Supreme Court case or is it a new ideology? And they can pursue the new ideology, but put it to Canadians and let Canadians debate it. We've never really heard whether Canadians accept this as inherently exploitive, that all Johns are to be demonized. This is something the government has listened to a small group of people who say that. It doesn't represent Canadians. So it can't be amended because the homework wasn't done before this bill happened. And I do appreciate the government was under the gun because they had a timeline. But when Justice Himmel invalidated in 2010, that's when they needed to start working on it, not in 2013 when the Supreme Court of Canada unanimously upheld Himmel.
Thank you, Professor.
Thank you very much for being here today, both
Thank
of you. Ms. Lang, you testified in front of the House of Commons Committee in July, and at that point you referred to an Australian study by Sheila Jeffries and Mary Sullivan about the effects of legalizing prostitution. And obviously in your short opening statement you didn't have an opportunity to discuss that, but I'm wondering if you could tell us what that particular study found.
Yes, that study found that rather than helping prostitutes in Australia with the legalization of the law, prostitution was expanded. What happened in Australia was that businessmen came in to Australia from various other countries and started building large casinos. Very opulent, attractive businesses that men and women both would want to attend. And then they opened, in these casinos, they opened brothels, legalized brothels. And so what you had was foreign businessmen investing money in Australia, opening casinos and brothels, making millions and billions of dollars. What they then found was that many of the girls that were working on the street could not be hired by any of these casino brothels because they were drug addicted, they had social problems, they had mental problems, and so these girls couldn't benefit from these legal brothels. And they also found that the small businesses that were envisioned with the legalization of prostitution in Australia could not compete with these opulent casinos. If you can picture something like the Bellagio in Las Vegas, that's what they were building. They found out, these researchers, the ones you referred to, that trafficking exploded. So sex workers were brought in from other countries, particularly in the state of Victoria. They were brought in from China. And so there was Asian sex workers brought in, and trafficking exploded. So the consequences of legalization, as I said in my very brief remarks, was a debacle there, as it has been in Holland. The plan to make this all better for women by legalizing it just has not panned out. And I agree with Professor Young that one has to scrutinize the research. And there are pro-prostitution groups as there are anti-prostitution groups. But when you look at a Swedish government study that was done in 2010 that completely debunks most of what Dr. Young has said with respect to the increase in street prostitution, driving it underground, that study from the Swedish government debunks that all.
Thank you. And just quickly ask for a concise answer to this one. I thank you for your comment earlier when you said this particular law, Bill C-36, is a radical departure from its predecessor. And you indicated at the House of Commons that the Bedford case found that denying prostitutes the safety of working in a permanent indoor location was grossly disproportionate with the objective of public nuisance and disruption. But the preamble of C-36 sets much broader goals, fighting exploitation, protecting human dignity and equality, and encouraging those in prostitution to exit the industry. So am I correct then in assuming that those particular much broader goals set by C-36 established in this bill's preamble bolsters its constitutionality in your learned view?
Absolutely. We're looking at a whole different plan, a program. We're looking at law that now says it's illegal. It was legal under the criminal code. In the Bedford case, we were dealing with a legal activity. But now the government has clearly said it's going to be illegal. We will not sanction women because we say they're victims and they're exploited. But certainly the whole constitutional landscape has changed with Bill C-36, and I believe it will be upheld.
Thank you.
Thank you. Joel. Welcome, Professor. You might have expected that question would be asked for you, which is essentially the constitutionality of Bill C-36. We have heard from government spokesman, the Minister McKay, and his Assistant Deputy Minister, as with some lawyers, that this bill will pass muster because it changes the premise on which the sections of the criminal code has been struck down by the court, by the Supreme Court, on the basis that, as you have read, of course, in the preamble of the bill, that any sexual selling of services is exploitative, any sexual services is harmful to the community, and any sexual selling of services breach the principle of equality of men and women. We have heard it from Ms. Lang before. So being a different basis or objective of legislation, the court would give precedence to those objectives who seems to be more important than the former one that were nuisance or public impediment for a peaceful enjoyment of public space. How would you answer to the court in relation to that argument?
Yeah, it's a good question. I mean, in my mind, on the merits, the legislation is clearly bad. In terms of the constitutional analysis, everybody thinks you just come up with your opinion within a week or two and it's conclusive. It's an evolving matter. I've read this legislation 3 or 4 times, and each time I've seen something a little bit different that I think may be constitutionally problematic. But on the objectives, there's no question, as was mentioned by the members here, you elevate the objective, you change the analysis. There's no question about it. The more serious the objective, the more you can justify the government's position. However, you can't just say in a preamble, these are our objectives. This high rhetoric, we're going to create a utopian society where men and women are all equal. It's a nice idea. You got to look to see whether the text of the legislation supports the rhetoric, and it doesn't. When you look at the things they're saying about how degrading and how divisive sex work is, how can you have a provision that says a woman can advertise for sexual services? How can you do that? How can you say you can hire somebody to assist you? If it's that bad, in accordance with the preamble, it should be an absolute prohibition. That's the confusion I'm talking about. So quite frankly, as a criminal constitutional lawyer, whether I do this case or not, I'll have a field day with that, because it's not a very straight message. I mean, you're still debating whether sex work is legal or illegal based on this legislation. You should know that by opening the first page. You shouldn't have to look at some circuitous drafting of legislation to figure that out. So, and I can just tell you this. The case in Bedford won on gross disproportionality, which is more harm than good. We're going to have to see whether or not this legislation does push people into dark alleys and make it more dangerous. But even putting that aside in terms of evidence, there's so many other things constitutionally suspect. We won on overbreadth. It goes too far. We won because the court would not accept that all sex work is inherently dangerous. It can be, the safety can be enhanced. Well, now the government's going to have to justify that all sex work is inherently exploitive. I'm telling you, the court doesn't really like these inherently exploitive statements. It's not nuanced enough, because we're going to call some great evidence to show it's not inherently exploitive. So, you know, you've got overbreadth because this law applies to rich people with their mistresses. You may frown upon that and think that's morally degrading, but I don't think there's a person in Canada that thinks the criminal code should be addressed towards rich people who hire mistresses. Secondly, we're going to have real questions about arbitrariness, which the court didn't deal with. The law has to achieve its goal. Well, if we find out in 5 years that everybody's been pushed out to the street because the Johns won't come indoors, then it's an arbitrary law that undercuts its very purpose. There's also things I would work on out of the Morgenthaler case about manifestly unfair laws. How can you advertise to men, Johns, and then as soon as they show up, entrap them into a criminal offense? That's manifestly unfair. There's something wrong about it. I can't articulate it yet, but I'm not in court, so I don't have to yet. There's the obvious equality claim about the differential treatment. There's even BNA problems. You can't grant immunity in criminal legislation. That's a prosecutorial task. So when they say, we will not prosecute women, the federal government actually can't do that. They create generic laws and they leave it to 92 BNA Act for the administration of justice by the province. They decide on immunity on a case-by-case basis, to be nuanced. So that's kind of where things stand. But in terms of inherent or harm to sex workers, we're going to have to wait and see. If you're going to rush to court as soon as this bill's enacted, that argument may not be on the table. There's enough arguments to knock out this law. But that's the one that I think we want to hear about, because the Supreme Court of Canada was really clear. Don't create laws that harm people. The law doesn't directly harm now, but it indirectly harms by its structure of moving the Johns back onto the street. And it's what's called a causation issue for the Supreme Court to deal with. It could go either way. But I'm not worried about it because of the other constitutional claims that I've mentioned.
Thank you, Ms. Lang and Professor Young, for your presentations. In the Bedford decision, the Supreme Court invalidated 3 sections of the code, sections 210, 211, and 213. Keeping those sections in mind, I draw your attention to paragraph 165 of the Bedford decision. As I recall in that paragraph, the Supreme Court talks about how all prostitution provisions are interrelated. In other words, they impact each other. There could be a greater latitude in one measure and less latitude in another. For example, permitting sex workers to obtain the assistance of security personnel might impact the constitutionality of another measure, such as forbidding the nuisances associated with keeping a common body house. I understand that you have 2 different positions. Ms. Lang, as I understand your presentation, do you believe that Bill C-36 strikes this balance? And on the other hand, I believe that you would disagree, Professor Young. So please go ahead. Ms. Lang?
All right. Yes, I do think that this bill strikes this balance. And just to follow up on a couple of points that Dr. Young made, this is not about immunity. This is not an immunity issue at all. This is about our government of Canada, duly elected, making laws for the good of the people, and saying that prostitution, women that are in prostitution will be decriminalized unless they operate in these areas. And Dr. Young suggests that you know, it's completely, it's an oxymoron, because you're saying it's degrading, but you're also saying that you can sell and all these other things, and you can advertise. But the fine line here is that the government has to make a law that will not be struck down. And I think that they have walked that fine line, and they've created a bill that will survive. And yes, I'm sure that many, in fact, I've heard that many of the members of Parliament in the Conservative Party would wish that it would be completely made illegal in Canada, that prostitution would be illegal. But it's not anymore. It was legal. It's now illegal for men to purchase sex, and women will not face criminal sanction. I think that this does walk the fine line, and that it will survive a challenge. And with respect to the other issues, arbitrariness and the B&A Act, etc., I'd like to hear those arguments fully explained. But I understand that this is not the day for that. Thank you.
Thank you, Ms. Lang. Professor Young, you wish to comment?
Very briefly, you're correct. It's all interrelated, and you can have a strong part of the bill compensate for a weak part. That's what the Court of Appeal of Ontario did. They upheld the communication law because they felt the safety issue would be solved by invalidating bawdy house and living on the avails. The Supreme Court of Canada didn't accept that, so I'm not really sure how they see the interrelationship, but I'll answer your question about proper balance. How can you even talk about balance when you're using the word asymmetrical? Because I know that's the word that's being used to justify the imposition of liability on one sector of the population and not the other side of the transaction. Asymmetrical generally is not balanced. It means it's teetering and it's sitting on a precarious foundation. So that's sort of my rhetorical answer to, is there a proper balance?
Okay, thank you.
Senator Plitt.
Thank you, Chair. Ms. Lang, thank you for appearing here today, and thank you for all the great work you're doing on behalf of the marginalized women and the exploited women and everything you're doing there. We really appreciate that. I want to get back to 213 of the bill and just get your specific view on 1.1. Tom Stamatakis, President of the Canadian Police Association, offered his support specifically for this part of the bill, where everyone is guilty of an offense punishable on summary conviction who communicates with any person for the purpose of offering or providing sexual services for consideration in a public place or in a place open to public view that is or is next to a school ground, playground, or daycare center. I know you supported the legislation before that amendment came in. Do you support that piece of the legislation?
I do. I supported it the way it was, and I believe that the amendment is necessary so that this legislation will pass constitutional scrutiny. And I believe that change is important. I think it does detail, so there's no mystery as to what areas women have to avoid falling into criminal sanction. And I do agree with that amendment.
Thank you. One more question, if I could. There's been much said about this won't work, this will drive it back underground, that we've heard that here today, so on and so forth. Very simply stated, though, if you take away customers, if nobody has any customers, if they're all either in jail or being punished in some way, does a business not shut down?
That's right. That's what happens, and that's what happened in Sweden, and that's what their government report from 2010 says, that street prostitution was cut in half, that a lot of women started working inside, but that they were able to curb and control prostitution because the purveyor of the sexual services wasn't around anymore. They don't want to be criminalized. They don't want to have their wives and girlfriends and children know that they go to prostitutes. So it's as simple as that, yes.
Thank you very much. Thank you, Chair.
Thank you, Senator Deschenais.
Thank you, Mr. Chairman, and thank you to both of our witnesses this afternoon. Ms. Lang, you heard Mr. Young's remarks, and at the beginning of his remarks, he said that there's a certain amount of tolerance on the part of the public with respect to prostitution. Now, I would say perhaps there's been some denial on the part of the public about exploitation of women and children in this regard. You expressed your perspective. And the purpose of Bill C-36 is to protect women and children, especially in areas where there may be children. Now, we've heard several witnesses, we heard them last week, and former prostitutes said that from their point of view, prostitution was not a profession, but rather a form of oppression. 90%, I would say it was a form of exploitation, and I think you've expressed that yourself. Several told us that they felt that they were sort of sex puppets, actually. And I think that that reflects what you've been saying as well.
Yes, that's correct. What I see in Vancouver is young Aboriginal women on the streets of Vancouver who come from their reserves throughout the province because they have no options there. They live in an alcoholic community. They've been raised in a family where there's abuse. They come to the downtown east side of Vancouver, and you can't tell me that these girls are making an informed, voluntary choice. It is their last resort. They have no money. They can't get on welfare, and they are quickly scooped up by the men who prey on these women, and they prey on them. I've been involved in a number of organizations that provide services to remove women that want to leave the street, and so I'm involved in that activity. I lived in the West End of Vancouver during the 1980s when the prostitutes were all over the streets. They were plying their trade, and it was a nuisance. But the fact is they are victims, and our government is now recognizing it for what it is. They are victims, they are oppressed, they don't choose this. The ones that do can go ahead, continue to choose it, and they won't be criminalized. So I don't see why they complain.
Merci beaucoup, madame.
Thank you very much.
I thought you did an excellent job deconstructing the myths around the arguments of the critics of this bill. One you did not address is that some of the critics of this bill say that those of us who support the bill conflate prostitution with human trafficking and underage sex. Is that a false equation? Can you separate prostitution from human trafficking and underage sex?
Well, that's an interesting question, and thank you for that. Yes, my submission in the Supreme Court of Canada was solely related to human trafficking. That was the topic that I advanced in the Supreme Court of Canada. And I've heard the argument that they're conflated. The fact of the matter is that prostitutes are trafficked. We know that. We know that Canada in 1959 signed a treaty where Canada recognized that prostitution was the forerunner to human trafficking, and that human trafficking was wrong, was bad, and had to be stopped. And that treaty now is still there, but we seem to ignore it. I think that when you talk to the police departments around Canada, there is human trafficking. These are women in various locations from Eastern Bloc countries, from Asia. And the fact is, they're not trafficked to work as nannies. They're trafficked to provide sexual services to men in Canada.
Thank you. And Professor Young, I wanted to understand your suggestion that Bill C-36 will create more street prostitution. And if I understood your argument, you were saying it's because it will change the behavior of the men, that they will be afraid for the entrapment of indoor sex. But what I don't understand, because you said that this is going to increase dangerous street forms, how do the same customers who were nonviolent indoors now become violent when they have to have sex outdoors, or when they feel
It's not the people who want to go indoors that are violent that I'm worried about. It's the Pictons, it's the Arthur Shaw crosses, the Joel Rifkins that are trolling the streets of Vancouver and Toronto. They're always going to be going outdoors. We're not seeing abductions from indoor locations. We never heard of a Picton fiasco. But to the argument, this is where it gets tricky, because before the law prevented women from taking safety measures. The law doesn't now. But de facto, what's going to happen is, I mentioned the analogy, you don't want to be a sitting target. You're going to be a moving target. I will, if I have to do this case, interview hundreds of Johns, do a survey to show that no one's going to go to these indoor locations that women are allowed to construct. This is about money, okay? So the sex workers are going to go where the money is. If the Johns are on the street, they're going to go on the street, which defeats the whole purpose of what the Supreme Court of Canada did and what the legislation should do. People will go where the business is. Will it be more dangerous than before? No one can say. I mean, people talk with a lot of rhetoric. It'll just be dangerous. No one should be working on the street, but that's part of the street trade. And I just want to say, when we talk about the survival sex workers, is that the paradigm in which we're creating our legislation? The police themselves have said 80% of the trade is indoors. Those are not survival sex workers. Survival sex work is a huge issue for us in terms of social services and welfare and taking care of it. But it should not be the paradigm for a criminal justice proposal on sex work. I'm sorry to have digressed there.
Okay, but just to be clear, you're saying it's not necessarily the case that outdoor sex work is any more dangerous or less dangerous than indoor sex work.
No. That was our whole case. All the empirical data was that you get a fourfold increase in morbidity and mortality when you work on the street. To me, it was common sense. I didn't even feel I needed empirical evidence, but there is a lot of empirical evidence to demonstrate that. So you want to avoid having a burgeoning street trade, because one, the community doesn't want it, but two, it's the worst place that you can do your business. Some people have no choice. Those are the survival sex workers. Those are the people we need to help to get off the streets.
Okay, well,
but we don't want to compel people to go where the business is on the streets, because we've said you can create a business, but anyone coming into your business that you advertise and invite in becomes a criminal. It's Kafkaesque.
But I will just say, when you said, did we hear uplifting stories at this committee, I didn't hear a single one myself. And, I heard stories of women being forced to have sex on merchant ships, in massage parlors. There's a case this week of Reza Moazzami. All his victims were forced to have sex inside condos. So the idea that indoor sex is some kind of great panacea, I strongly disagree with you on that.
Senator Frum, if you would give me the opportunity and have another meeting, I will bring you those stories for you to hear, because I don't know who you're inviting. And maybe uplifting was too strong a word. Okay, but I wanted to say there are stories of people who are content with their choices and want to continue those choices unimpeded by state interference and ideology. But if you haven't heard those stories, let me bring them to you. And about public opinion, I would do that too. You say you're not sure what public opinion is. We've done so many surveys since 1970 that all being erased because the government says they sent out some questionnaire before this legislation that wasn't even monitored for multiple submissions. So if you want further evidence to make an informed decision about the bill, I'm the person who'll provide it for you if you want.
Okay, Senator McInnes.
Well, it's very interesting, Professor. I kind of sensed that the manner and style, procedurally, how we got to this point today of this bill being before us, I would almost say vehemently disagreed with.
Mm-hmm.
And the Supreme Court stated that we would have a year, the government would have a year to bring in new legislation. And without that, I think it's December the 13th or the 16th, it would be open skies. Pimps would be running businesses. It would be big business people. But you can take a deep breath. Lots of time to respond. And you of course disagree with the Nordic model, but we hear evidence that it's worked. You've, I think, just now alluded in not a good way about and I think you were talking about the consultation that was done by Justice, where specific questions were asked, and individuals, it was not like a poll, it was individuals taking the initiative to respond. There was a paper put out, there was Facebook, and so on. And so the direction of this bill got a majority, pretty substantial majority in some instances on the questions. So then the Department of Justice drafts the legislation. In addition to that, the lawyers in the Department of Justice say And we're not, because of client solicitor privilege, we don't have that before us, but they say that as has been mentioned earlier in this setting, that it'll meet the muster of any challenge. You say it won't. Then it appears before the Commons, where you have a majority elected individuals, but all elected officials have a right to discuss it, debate it. It goes before the Commons Committee, where it's debated and discussed. And I'm sure the public are talking to those politicians. The Senate, it comes here. We have hearings. And we've heard professors who disagree with you. And we have many that come before us who disagree with you. Some agree with you. Democracy can be challenging, but I've yet to see a better system anywhere in the world than what we have, the democracy that we have, and that is the system that we have. And so you have every right to come here and disagree. In fact, you remind me of a friend of mine who's a professor at the law school at Dalhousie University, who has the same approach, and I always respected it. And I respect you for having the right to come here before us and state it. But I'm just going to say this. I'll just say this, and I'll close it off. Look, this is the system. This is where it's come to. And as I say, if it is challenged, and whether you're the person that does it, that you have every right to do that. But I suggest to you that the manner and style in which this legislation has come before us, I think, quite candidly, is second to none.
Am I allowed to respond? Okay, thank you. You said a lot, so I'll see if I can deal with it.
Well, you are time limited in your
response.
response.
I realize that. And I appreciate that you think I have a right to disagree, but the real question is whether anyone's listening. That's the real question. But in any event, you mentioned the Swedish model. I have to point out, it is not that clear. There's a lot of conflicting studies on it, and it's probably the worst jurisdiction to rely upon because it didn't have really a problem with the sex trade. You got to know a little bit about the historical evolution of sexuality in Sweden to understand what I'm talking about. But it was an ideal experiment because they couldn't fail because they don't have a big sex trade. But in terms of democratic theory, I'm not taking on democracy. I understand the systems work. Sometimes it's dysfunctional. But you can't tell me that what the government did before this bill in terms of a consultation was meaningful. You can't have email submissions without controlling for what are called multiple submissions. There is no pro-prostitution lobby, but there sure as hell a strong abolitionist lobby. And I know I've been dealing with them for many years as they've been criticizing me and condemning me. And they'll sit there and they'll send 20 submissions in saying, I think it's degrading, I think it's degrading. So it's not surprising that the government would get the response they wanted to get because they set it up in a way that there was no controls for it. Secondly, there is no privilege to a legal opinion done by Department of Justice lawyers. You're entitled to see that. I can't believe we would say solicitor-client trumps what the public is entitled to know. And with Edgar Schmidt going to the federal court suggesting the Department of Justice does not review their bills for constitutionality, I can't sit here and feel good about this being vetted extensively by this department in the couple of months they put it together. And finally, in terms of the House of Commons, if you want to know what people think about the bill, do an independent vote. Don't vote on party lines. You got a majority, you're going to get what you want to hear. But if you were to ask people individually, you will find there's a great deal of tolerance for this. Not everybody wants to run to criminalization as readily as this government.
Okay, that was a fulsome response, and we'll go into a second round with Senator Baker.
Thank you, Mr. Chairman. And Senator McGuinness mentioned the hearings in the House of Commons, unfortunately, and to me it defies logic that Alan Young was not invited, I don't think, as a witness before the House of Commons on this bill.
Make it on the day I asked for another day, and as I said at the beginning, I am saddened and disappointed by this. This is the first time I'm talking about it, which may be why I'm a little bit more hyped up than I should be. So I apologize for that, but I've been keeping a very silent vigil watching this.
Okay, well, it's nice to have you hyped up. Now, here's the key question on a lot of people's minds. You've mentioned that when this new law comes into effect, that you suggested that we need an evidentiary foundation in order to challenge the bill, some people have suggested that the evidentiary foundation is already there with Bedford, and therefore the matter should be referred to the Supreme Court of Canada for an opinion right now. What's your views on this?
I think that might be a mistake, and I was actually one of the people to have said that. That was my first response to the bill. I think, I didn't say this earlier, the communication provisions, those are so clearly unconstitutional. I mean, just read the decision. You can't simply replace the same verb and say it's constitutional. So that could be challenged immediately and should go to the Supreme Court. But the other stuff is more complicated. And the evidentiary foundation that's before the Supreme Court, the 88 volumes, the 27,000 pages, helps. But the focus has shifted. The Bedford case was about the demographics and lifestyles and choices of sex workers. This is now going to be about the Johns, because that's what's fueling this legislation. Are they all inherently exploitive, and should they be demonized? And there are John studies. I know them. They were tendered in our case. But the focus now has to shift. Has the government created an overbroad piece of legislation because they've lumped all Johns into one category? That's what happened in Bedford, where they lumped all sex workers into one category, inherently exploited, and the court didn't accept it. So some homework has to be done. There are some researchers in Canada who've looked at Johns, but they've also done studies in Sweden and in Scotland, which aren't favorable for what we would try to achieve. So that's why I'm saying it's a bit complicated. The evidence gets us halfway there, but the one thing I know about constitutional law, if you don't have a good evidentiary foundation, you're not going to convince a court. So to run to court right now with rhetoric and say, oh my God, what has the government done, would probably be a mistake, though I'd like to see somebody do it on communication alone, but you generally can't refer one section, you have to refer the whole
So we're
piece.
looking 5-10 years down the road before we get an answer as to the constitutionality of this legislation. If it were done in criminal proceedings, or if it were done in civil proceedings. Do you have any prediction as to, and do you agree with me that it's going to take that long period of time before this challenge takes place, and whether or not it will be challenged under what rules of court? Criminal, civil, federal? What do you think?
It probably will be the same sort of process that I adopted, which is an action for declaratory relief, because, you know, in the charges that they lay against Johns, they'll just pull the charge, so you can't do it. And you have more control that way. You're right. It's 5 to 10 years, sadly. There are probably ways to speed it up. There are provisions in the Supreme Court of Canada Act where they can request evidence, so you can put it to the court and let the court wait some time for the evidence to be put before them. But there is something else that's interesting. When the communication law came out in 1985, a lot of people say, oh my God, it's going to hurt people. It's going to cause a dangerous situation. The government said, no. You know when we knew? After the 5-year study, which is required in this legislation too.
I see.
So I don't want to wait for 5 years. No. I don't think that's fair to sex workers or to the communities that are affected by this, but that will be our first real indication, unless private researchers start to do the work, as to what is the effect of this bill. Because you can, for constitutionality, it's not just the purpose of the legislation, it's also the effect. And the effect is always about evidence. And there is evidence now that we could run this challenge, but to do it properly, I think we'd have to wait. And I don't know if I can wait or other people can wait, because every day people are being exposed to the violence on the streets, and we need to have a resolute conclusion to this debate.
Thank you.
Thank you very much. Ms. Lang, I wanted to tell you that I really appreciate the comments that you made about Aboriginal prostitutes in Vancouver. I come from Saskatchewan, and what I have seen in Saskatchewan is that the average prostitute is probably a 14-year-old Aboriginal girl who's probably been beat up by her pimp that morning and is likely drug addicted. So that's what we're dealing with in large parts of the country, and I appreciate your comments about that. Professor Janine Benedet testified before us last week, and she talked about Section 15 in the context of C-36, and she said to us. The way that the constitutional challenge in Bedford was constructed, it was strictly a Section 7 question and attempts to bring equality into the balance and demonstrate the ways in which the prostitution industry is deeply gendered, the ways it preys on equality were kept out. These laws were not designed to address equality. That was not part of their objectives, and they had much narrower objectives. What is gratifying about the way Bill C-36 is constructed is that now those objectives are now clearly in the bill. Sex equality is a principle of fundamental justice, and we need to consider that in the analysis as well. And I would like to get your comments about that.
Yeah, I absolutely agree. When I was making submissions in front of the House, one of the questions was, why wasn't Section 15 dealt with in the Bedford case? And of course, it wasn't structured that way. But I agree with Professor Benedette that with the clear preamble that talks about equality of women and how prostitution is something that denigrates women and does not make them equal, makes them sex providers for men. I think that equality will be an issue in the if there is a challenge, and I expect there will be.
Thank you. And just a very brief question to Professor Young. You spoke in your opening statement about all the pro bono that was done, work that was done on this particular case. And when Ms. Bedford was here last week, she talked about spending $500,000 on her case. So who did she pay that money to if so much pro bono work was done?
I wasn't here. I heard there was a bit of a fracas.
You heard about that, did you?
I'm not exactly sure what she was trying to say. The simple truth is...
So she didn't pay that to you? Okay.
No, I wouldn't be here if she had, okay? I'd be in the Bahamas right now, okay?
Right.
So the case waited. I had to wait a few years because the court challenges program turned me down in 2002. That was after the Picton pig farm. So then in 2006, I went to Legal Aid Ontario, and they gave me $40,000 out of the test case fund for disbursement so that I could pay for witnesses to fly from Vancouver or Edmonton to be cross-examined by the Crown. I did the work pro bono. The students did the work pro bono. Most of the other lawyers did it pro bono. At the Supreme Court of Canada stage, my co-counsel were on legal aid certificates. But we're talking probably, if this was through a regular law firm, it's probably about $1 million in terms of total.
But it wasn't.
No,
Yes,
no.
absolutely.
But the thing is, that's the tip of the iceberg, because it was me, okay? I was up against 8 government lawyers. So you start doing the calculations about how much money the government spent to defend this legislation. That's one of the reasons why I made that comment, a little bit sarcastic, is get it right the first time, because these constitutional challenges are hard to do and beyond the resources of most people. And I'm fortunate that I can do this work because I have a team of students that you may say I exploit, because we like to talk about exploiting today, but that I can utilize.
I was a law student many years ago myself.
Okay, but that I can utilize so that I don't have to do a monumental amount of work myself, because this was a big case, probably the biggest case I've worked on in terms of the volume of evidence.
Thank you for that clarification about her claim.
Yes. I'm not sure where that came from.
Okay,
Sorry.
Senator Joa.
President. Professor Young, I want to come back on the immunity provision of the bill, 286.5. You have described it simply by saying if you are allowed to offer a service, to communicate to public that you are available for the service, if you can hire people to help you to provide the service, how can you in reality declare that anyone who purchased your service is a criminal? I have put that question in those simple terms to Mr. Perigoff, who happened to be the Assistant Deputy Minister, Relation of Public Policy at Justice Department, and his reasoning is the following. Well, prostitution is illegal per se, and what is given to a person who offers her own or his own service is immunity of prosecution, but the act per se is still illegal. So it is possible, in legal terms, to criminalize one aspect of the reality, which is the purchasing, and keep a blind eye on the other part of the equation. How do you respond to that legal interpretation of Section 286.5.
It just makes the law seem so confusing when you're describing how Don Piragoff is saying it works. I mean, that's not the way law should work. It should be a lot clearer and more linear, but I don't know. I have to think about that more, but I can tell you this. As a criminal law professor, when you're just criminalizing one side of a transaction, this is the first time this has ever happened. There's no historical precedent for this. I can't even imagine one. And I tried on the plane up trying to think of some example historically at common law or by statute where we've done it. So it's an oddity right from the beginning. And what's going to be the real claim is a claim that does emanate from the Morgentaler case and the medical marijuana cases. You can't set up a manifestly unfair regime. Okay? So it doesn't matter whether you call it legal or immunized. The reality is, nowhere in the history of law have you ever allowed a private citizen to say, come to me, I can sell you something, and then turn around and arrest them for coming. That person who's doing the selling is either the main perpetrator, and I understand what the different logic is here, but at a minimum, they're a party to that transaction. Mm-hmm. So when the government says you cannot prosecute for it, they've made a mistake. They've created the offense. Party liability exists under Section 21, and the only level of government that can immunize for prosecution is the province. So they've gone about it in a very strange way. And I don't know what it means, and that's why I was a little bit reserved, saying it's going to still take me some time to come up with a conclusive opinion. But I can just tell you, I've never seen anything in the history of criminal law that sets up what they're calling asymmetrical prohibitions. It cuts against the grain, and it's hard to justify. And I think the government's going to have a hard time ultimately justifying it, whether they say everything's legal, everything's illegal. It's just not a very clear way to go about stating what your government's position is.
But would you say it's a criminal policy issue, or is it a constitutional issue?
No, it's a constitutional issue. That's why I use the words manifestly unfair. That comes right out of Morgentaler. Very different type of scenario, but it was a situation where they set up a regime, but it simply could not work for women who were seeking abortions because procedurally it was cumbersome, obstacle-laden. But they say it violates the principles of fundamental justice to establish liability in a manner that's manifestly unfair. And I say, not holding any torch for Johns, but if you're advertising your services, you're opening your door, you can't criminalize that activity without criminalizing the very people that have encouraged it. I mean, you've actually just legalized entrapment. That's what's happened. Mm-hmm. So I'm not able yet to articulate the constitutional dilemma, but if you asked me in 2003 what my constitutional argument was for Bedford, I didn't have it yet too. These things evolve. Mm-hmm. And let's say the Insight case in British Columbia fueled a lot of this too. Mm-hmm. So I'm waiting to see what comes out of the court over the next couple of years. But again, I come back to my comment. I just sad that may have to wait for a couple of years. But I strongly feel that the way they set it up is criminal law is a trap. And I take criminal law seriously. Yeah. Okay.
Thank you, Chair. I will, Ms. Lang, I would like to ask you two very, very quick questions here. I'll put them both to you at the same time. The first question is, what would you say to critics of Bill C-36 who say that it is not the place of the government to interfere with an act between two consenting adults? My other question, and this one will be speculation, I know on some part, but I would like your thoughts anyway. We have not had a barrage of Johns wanting to come here and testify. Why do you believe that is?
With respect to the issue of government interference in a private sexual act, in fact, it is the only people that can interfere is our government. We elect our legislators. They are elected democratically. They can create law. If the law passes, if the House of Commons passes a law, that is the only person that can, or the only people that can. As far as judicial activism, judges are not empowered to legislate. They shouldn't make the law, and in fact, they are not elected. They are appointed. The only people that can make law, and I say it is within the government purview to make law to protect women and to enshrine equality in our law. The second question about why the Johns won't come. Well, it's pretty obvious. In my view, they know that what they're doing is exploitive. They know it's wrong. They're embarrassed. They're ashamed. particularly the ones that are having sex with underage children, and there's plenty of them doing it. And I think that it's going to be very difficult to get information from Johns, because they're not going to say, pick me, I'm one of those people, and that's the problem.
Thank you very much. Thank you, Chair.
And the final question goes to Senator Dagenet.
Merci, monsieur.
Thank you very much, Mr. Chairman. I think Mr. Young answered all my questions without me having to put them.
Well, I hope adequately.
Thank you, both witnesses. Very interesting and helpful testimony, and much appreciated.
Thank you very much.
Thank you.
Yes. And members, just to remind you that we meet again at 10:30 tomorrow, and we'll see you all then. Meeting adjourned.